I am delighted to introduce our keynote speaker for the afternoon, Jamal Green, who was a distinguished commentator at our first National Conference of Constitutional Law Scholars, and we're just extraordinarily pleased to have him back. Today, he's going to talk about Rightism. Without any further ado, I will turn things over to Jamal, and I will keep the cue for this session. I think he's going to speak for roughly 30 minutes, and then we should have about 30 minutes for questions, give or take. Jamal, so nice to have you here.
Thank you. I'm happy to be here, and thanks to all of you for spending a little bit of your Saturday afternoon with me and with each other. I also just want to thank David and Brad as well for hosting this and inviting me to talk to all of you. I've spent a lot of time over the last several months talking about various topics, including some that are very much related to what I'm going to talk about today, to a very wide range of audiences. That's both because, as some of you know, I sit on the oversight board for Facebook and Instagram. So I've been talking to a lot of kind of tech-related and tech-adjacent audiences. And also because I have a book coming out, book's called How Rights Went Wrong. It comes out on March 16th, and it's a trade book. So that requires spending a lot of time talking to non-scholarly, non-lawyerly audiences. And I'm kind of excited because today I get what feels like a rare chance, at least in recent months, to talk to law professors, and in particular to talk to public law professors about my work. And it's something I feel like I genuinely miss doing. So being able to talk to an audience by going straight to level 2 or to level 3 or to level 4 of the argument without having to do too much laying of groundwork kind of feels like a homecoming. So I appreciate being given the chance to do that. And in honor of that opportunity, I'm going to do two things. So one, I'm hopefully not going to spend nearly the time I have just lecturing. I think we have an hour. I was initially told I should leave at least 15 minutes for Q&A, and hopefully, as Andrew suggested, I'll be able to leave, something closer to twice that amount of time, since you're all smart and knowledgeable people, and I can learn a lot from you. So please ask questions when I'm done speaking, because that's what I'm interested in. The second thing I'm going to do to kind of honor the audience is I'm going to start this talk in a way that I've never started a talk before, which is by talking about a constitutional law casebook. And the particular casebook I'm going to say something about to start is the one that I use in my own constitutional law course, which is that giant beast of a casebook known as Brecht-Levinson. And now I think we all, I suspect, have some things that we love about Brecht-Levinson, and perhaps some things that we love somewhat less about Brecht-Levinson. But I want to talk about something that I love about it, which is that when the casebook gets to Marbury versus Madison, the authors go meta. They talk about the process of editing a case for a casebook, and how casebook authors have to make certain choices about what to include and what not to include. And the authors center a simple, but I think incredibly rich question about Marbury. They say something similar about McCulloch as well. Namely, what are the facts of Marbury versus Madison? What are the facts of Marbury versus Madison? And it's a simple question on one level to people who have been socialized as American law professors. We interpret the question as, how is it that this came to be litigated and came to be sitting in front of a court? So, lawyers hear that question and they think, well, William Marbury was selected to be a justice of the peace and he didn't get his commission and so forth and so on. But the casebook wants to push students to think about the broader universe of political and historical questions that are relevant to how a case is decided, right? So in the case of Marbury, the facts aren't just, William Marbury wanted his commission and then he didn't get it, but might require a more fulsome description of the dispute between the Federalists and the Democratic Republicans, or an historical assessment of the role of transitions, political transitions in a new republic, and so forth. And both how we describe a case and how we evaluate a case normatively can change depending on what we take the legally relevant facts of the case to be. And I want to focus today's discussion on a version of that question that I think we need to ask more broadly about the set of materials that constitutional judges and constitutional lawyers confront in building and deciding a case. Namely, what are the legally relevant facts of a dispute, and specifically a dispute involving claims about rights? And the argument that I'm going to advance is that we spend too much time talking about what I'm going to call interpretive facts. And I'm using facts pretty broadly here, right? But what I mean is the meaning of the text, the nature of the right at issue, and not enough time talking about what I'm going to call, just very colloquially, real world facts. The government's purposes, means, ends, fit, the cost of the government's actions in rights terms, the benefits in terms of the government's legitimate objectives. So I'll give an example of what I mean and then move on. And I'll use Citizens United as an example, since this is a case that's familiar to this audience. The interpretive facts of Citizens United, and again, I'm using facts broadly, so we don't need to argue about nomenclature. So the interpretive facts, what is a speech restriction? What counts as a speech restriction? What tier of scrutiny do burdens on speech occupy? Do corporations have speech rights? These are the kinds of questions Anthony Kennedy asked and answered in his majority opinion in Citizens United, and their answers basically led him pretty directly to his conclusion. This is a speech restriction. Just because it's money doesn't mean it's not a speech restriction. Strict scrutiny applies. Corporations do have speech rights, and basically QED, right? There's not a lot of analysis beyond the answers to those questions. Now, how would someone who is focused on what I've called real world facts have approached Citizens United? Let's get past the questions about free speech rights. Free speech is implicated in Citizens United. Let's concede that fairly straightforward legal premise, exactly as straightforward as Justice Kennedy makes it in his majority opinion. What are the real world facts? These are the facts of the conflict between a litigant and the government. On one side of the dispute, you have an ideological nonprofit corporation which is trying to criticize a candidate in an election whom it views as hostile to its political objectives, in this case, Hillary Clinton. So it makes a movie about the candidate, and rather than putting that movie in theaters, it distributes, there used to be a thing called movie theaters, by the way. It distributes it via video on demand in the weeks leading up to the election. That's one side of the conflict. On the other side, the government believes that corporations are abusing the corporate form in order to dominate electioneering, drowning out the voices of individual citizens. So it passes a law that says corporations who want to engage in certain kinds of electioneering, but not others, within 30 days of a primary election or 60 days of a general election may still do so. But in order to do so, they have to do so through a separate political action committee that segregates political funds from general treasury funds. Viewed through the lens of real world facts, the dispute in Citizens United is not an abstract, stylized dispute between a government that wants to restrict speech and a set of citizens who want to exercise their free speech rights. The dispute is between a government that believes it is, or whose principles believe that they're protecting the political rights of their citizens through a quite specific law. And a corporate citizen whose directors think that that law goes too far towards interfering with their freedom of expression. Citizens United is a dispute between parties. That's what the dispute is about. The relevant questions then become, well, is it true that the government is trying through this law to protect the political rights of its citizens? Is it legitimate for the government to protect the political rights of its citizens in this way? Does this law go too far toward interfering with the free expression of this litigant? And in answering those questions, the kinds of things we might care about are not abstract things, right? We might care about what is the evidence that ordinary citizens are unable to participate meaningfully in the political process under the status quo. That wasn't discussed in Citizens United. We might care about the burdens associated with a corporation having to rely on a political action committee rather than relying on its general treasury funds. Remarkably, that wasn't discussed in Citizens United. We might care about the difference in the level of audience capture between television ads, which were the main anticipated target of the McCain-Feingold provision that was invalidated in Citizens United, versus video on demand, on the other hand, which is a very different kind of technology than ordinary political ads, not discussed in Citizens United. We might care about the difference between the speech interests and the benefits derived from the corporate form of a closely held corporation versus those that might be publicly traded on stock exchanges, not discussed. We might care about the difference between ideological corporations along these dimensions, such as Citizens United, versus those that sell things like General Motors, right? Not discussed. Those issues aren't discussed because the way Americans think about rights, at least this is my claim, the way Americans think about rights has encouraged us to think that rights conflicts are about the rather abstract legal interpretive questions like, is money speech, as opposed to being about real world facts. At the heart of that tendency is what I refer to as Rightism. Rightism is a disposition to view a rights conflict as a question about what the right is and whom it protects. This may seem very natural to American constitutional law professors, right? But the alternative to Rightism is to view a rights conflict as a dispute with important values sitting on both sides of it that require no abstract discrimination between rights. A rightsist views rights conflicts as an opportunity to declare what rights the Constitution protects and what rights it does not protect. Rejecting Rightism means instead viewing rights conflicts as a natural outgrowth of pluralism, as a legitimate, often legitimate, values conflict that is in need not of declaration of rights, but in need of mediation, something that we recognize in other judicial contexts. There's nothing inherent in the nature of rights conflicts or constitutional rights conflicts, or in the nature of constitutional rights conflicts that are submitted to judges that requires judges to resolve them through Rightism. And in fact, I think the various proportionality frameworks that have been adopted in many other countries tend to do a better job of avoiding Rightism than the American approach, which is a kind of categoricalism. So let me say a bit more about how I think we got here, and then say why I think it's a problem that this is where we find ourselves. We sometimes associate what I'm calling Rightism with the founders, right? We tell something like the following story. The Bill of Rights sets out a code of rights, and those rights are particularly in need of protection. When we get a rights dispute, our task, the judge's task, is to figure out which of those rights is engaged, if any. When engaged, those rights are protected robustly. They're listed there in the Constitution because they're meant to be taken out of the political process. And so any kind of balancing reintroduces majoritarian politics, which defeats the purpose of having rights in the first place. Now, This might or might not be an attractive vision of rights adjudication. I think it's not, as I'll get to, right? But in any event, it's wrong to associate this vision of rights adjudication with the founders. The founders believed very strongly in rights, but they did not believe strongly in judicially enforced individual rights that were absolute or anything close to it. Rather, what the Bill of Rights protects or seeks to protect is the set of localized political institutions that the founders thought were needed to work out what the people's rights would be. So what was guarded zealously against federal interference was the right to live in a self-governing community. That community, acting through its local legislatures and councils, through its juries, through its parish churches, through its family units, through its militia, would determine the metes and bounds of individual rights and indeed protect them from outsiders, including federal judges who are outsiders to those self-governing communities. Embedded within the Bill of Rights is a social and primarily majoritarian understanding of rights, not the liberal, quasi-libertarian version that Americans too reflexively associate with and ascribe to the founders today. Now, there are lots of problems with this way of thinking about rights in the 18th and 19th centuries, right? Most prominently, the self-governing communities at the heart of the Bill of Rights were exclusive ones, right, that gave political power only to white men. This obviously won't do when we're talking about rights in a pluralistic society, because of course, many of the people whose rights were in need of protection were not empowered to participate in self-government. And so, oversimplifying a bit, the Reconstruction Amendments, we fight a big war, Reconstruction Amendments are meant as a solution to this problem, right? It's a recognition that even local governments can't be trusted with the rights of minorities and the rights of political outsiders. And so the Reconstruction Amendments empower judges and empower the federal government to protect the rights of those people. And it directly forbids, in the 15th Amendment, directly forbids, excluding at least some of them, from the local political processes that are going to be are going to form those self-governing communities. Now, you're all con law professors, so I can move quickly through what followed, right? The rights that ended up being protected under the 14th Amendment were not the rights of minorities, and those minorities continued to be excluded from local politics. Instead, the majestic language of the 14th Amendment succumbed to the demands of powerful economic actors during the Industrial Revolution and afterwards. That majestic language ends up being repurposed away from racial exclusion and towards protecting the right of companies to pay poverty wages, to resist unionization, to resist collective bargaining, to stymie health and safety measures for workers and consumers, and so forth. Familiar story. The New Deal settlement and Caroline Products footnote 4 represents an attempt to recover something closer to the animating political moral vision of the 14th Amendment, while at the same time vindicating the progressive era social welfare project. Defer to legislatures, which can be trusted with the political judgment to pursue an economic and social welfare program, but don't defer when legislatures are violating specific constitutional provisions or when they are uniquely undeserving of trust, as when they are engaged in acts of political self-dealing, or when they're passing laws that disadvantage discrete and insular minorities. The paradigmatic violation of constitutional rights under this framework is Jim Crow and McCarthyism, or other forms of overt political exclusion of one's ideological opponents. And of course, John Hart Ely's famous book, Democracy and Distrust, further cemented within the minds of modern constitutional lawyers a connection between rights and distrust. Judges step in to protect rights when legislatures cannot be trusted. And under footnote 4, those situations are determined categorically. So we try to figure out if we fit into that category of distrust. Now, that might work fine, right? If the only rights conflicts that you're talking about are Jim Crow and McCarthyism. right? In those circumstances, aligning rights with distrust makes a lot of sense. The government actors in those situations are in fact unworthy of trust, right? But that kind of categorical Manichaean framework of either you trust the government completely or you don't trust it at all becomes deeply problematic when we're talking about other kinds of rights conflicts. In fact, when we're talking about most kinds of rights conflicts, that becomes obvious when you look at the conflicts that arise in the 1960s and 1970s involving an explosion of rights claiming, sexual and reproductive freedom claims, gender equality claims, affirmative action claims, disparate impact claims, claims in the criminal procedure space, like Miranda rights or the right to a government lawyer or the right not to have exculpatory evidence concealed by government prosecutors. Free speech claims that don't look like McCarthyism, but they're claims about campus speech or about pornography or obscenity, or that involve provocative forms of activism like burning your draft card. Government support for religious institutions, religious schools in particular. Claims about people asking for more welfare benefits or more process before their welfare benefits get taken away, or access to government benefits like tenure at a public school, or access to a driver's license, or making sure your gas doesn't get shut off by the local utility, right? For all of those kinds of claims, which is it, right? Is it that we need to trust the government entirely, like in West Coast Hotel versus Paris, defer to them absolutely? Or is it that we can't trust the government at all to be pursuing any legitimate objective when it decides how much welfare someone should receive or not receive, as in Jim Crow or McCarthyism? It's neither of those things. And of course, it's neither of those things. It's somewhere deeply in between. And yet we've persisted with this categorical framework that tries to fit claims into these binaries. Both sides do it, right? Conservatives have resorted to various strategies, including originalism, right? As a strategy for getting at the true constitutional rights, right? What are the right ones to protect robustly so that they can exclude rights to abortion or rights to same-sex marriage, but include rights to commercial speech or rights to guns, or at least lately, rights to religious freedom. And progressives have resorted to a variety of theories as a way of getting at the true constitutional rights so that they can include the ones that the conservatives want to exclude and exclude the ones the conservatives want to include. And so everyone ends up being a little bit rightsist. In this way, constitutional rights polarization aligns with political polarization over exactly the same issues, but it does so only indirectly by translating political debate into debates about what the framers really thought, or debates about whether strict scrutiny or intermediate scrutiny applies to a particular situation. Lawyers like us then come to believe that these abstract legalistic questions are what rights conflicts are about, right? That those abstract legalistic questions get at the legally relevant facts of a rights dispute. This way of thinking about rights leads to at least three, and probably more than three, serious problems. Problem number one, it decouples the vital link between rights and justice. And so, in a disparate impact case, instead of asking about real world facts, like what is the government trying to accomplish? What is the magnitude of the disparate impact? What are the alternatives available to the government policy that led to this disparate impact? Who's being affected? Is it some group that has been historically disadvantaged or not? All of those questions speak to the justice of the government's actions. And they speak in the register of equality as well, right? So when I say justice, I don't mean moral justice decoupled from constitutional law. I mean the exact words the Constitution uses. So instead of asking those kinds of questions, we just ask in a case like Washington versus Davis, whether disparate impact is just the same thing as intentional discrimination. Concluding that it's not, we say the Constitution has nothing to say about it. Or in a case about school funding equity, San Antonio versus Rodriguez, right? Instead of asking, well, why does this inequity exist? What is the state of Texas trying to achieve? What's the magnitude of the inequality? Is there some way of reducing this in ways that are consistent with the government's objectives and fiscally feasible? Can we mitigate the problem in some way without fully solving it, right? Real world facts about justice. Instead of asking those questions, we instead ask, well, is there a right to equal public schools? Concluding that any such right would mean that there must also be a right to things that are kind of like public schools, like police funding, or that the right to education, if it's really a constitutional right, means that lots of other things that are important also have to be constitutional rights, like the right to food. And that can't be right. And so therefore, there must be no such right. Right? We look at the legal categories as being what the dispute is about, instead of looking at the real world facts, distorting the relationship between rights and the justice that rights are meant to promote. Problem number 2 is that the rightsist way of thinking prevents us from acknowledging that genuine rights conflicts can coexist, right? And therefore need to be resolved at retail rather than at wholesale. We see this in the abortion rights area, where in Roe versus Wade, Justice Blackmun, without analysis, concludes that recognizing anything like fetal constitutional rights has to mean that abortion restrictions are always permitted. The Roe court's failure to recognize that fetal rights were at issue and had constitutional dimensions had an immediate impact on the anti-abortion movement, and in fact split it in two, with the more radical camp eventually vanquishing the more moderate camp within a couple of years of Roe versus Wade being decided. That split in the anti-abortion movement then gets catalyzed in various ways by the moral majority and others, which ends up making political compromise around abortion nearly impossible, even though intense moral conflicts are exactly what politics rather than adjudication is meant to resolve. Problem number 3, a related problem. The categorical frame means that every dispute is about whether you're in the category of rights holders or the category of non-rights holders. Are you living in heightened scrutiny land, or are you living in rational basis land? You might all recall from the Bakke case, Justice Powell's separate opinion, lamenting that if the dissenters were to win the case, right, the only people living in rational basis land would be white Anglo-Saxon Protestants. And this is not me making this up, right? This is what he says explicitly, and that everyone else would get to live in the wondrous heightened scrutiny land, right? And he says that this leads to social conflict. But what he's really modeling, in his opinion, is the fact that rightism leads to rights envy, right? And raises the stakes of constitutional conflict. So in the pandemic, right, it's about whether there's a right to hold a religious service or whether there's a right to wear a mask, to not wear a mask on the one hand, or a right to public health on the other. And only one of those camps gets to win. So we're gonna, and name your favorite constitutional conflict, whether it's conflicts over voting rights or whether it's Masterpiece Cake Shop-like issues, which will soon become Fulton-like issues, or affirmative action, or a wide variety of speech-related conflicts. Similar dynamics appear. Our constitutional rights arguments recreate our political arguments, right? But they do so while claiming legal interpretive certainty and while studiously avoiding the language of deliberation, of negotiation, of moderation, of mediation, the language that characterizes politics in its ideal form. This then means that when political actors talk about these disputes, they recognize that these disputes implicate constitutional rights, and that leads them to defer to judges and to the zero-sum legalisms that judges celebrate. Why negotiate, right, towards some politically mediated solution if it's just going to go to court anyway and then get resolved in some zero-sum way that's going to align with the judge's political tribe? Let's focus on making sure the judge's political tribe is the same as ours, right? Might as well put your foot on the political gas and maximize what you're going to get out of a judicial win. So I'm going to more or less stop there. I have more to say about this, of course, right? But I'm going to more or less stop there and just say that it will come as no surprise that I don't think this is a healthy way to go about resolving constitutional rights disputes. And the thought I'll just leave you with before going to whatever questions you might have is this. The reason our constitutional rights disputes align with our political disputes is not because judges are activists, right? It's because rights disputes are political. And we can decide to remove judges entirely from those disputes. I think that's a bad idea on the merits, and also something that's too late in the game. That's one option. Another option is we can continue to be rightsist, which I think has the destructive consequences I've just outlined. Or we can look for a third way, one that focuses on real world facts, one that seeks to promote mutual respect, one that does continue to empower judges, right? But also tries to restore some constitutional responsibility to the political process. So I'll stop for now and look forward to hearing your questions, comments, challenges, and concerns.
Thanks so much, Jamal. That was really terrific. As a reminder, if you have a question, please type Q in the group chat. I will get us started. I'm wondering to what extent the phenomena you discuss, the categoricalism, and in particular, the indifference to real world facts are unique to the jurisprudence of constitutional rights. It seems to me that a lot of structural decisions, especially recent structural decisions, exhibit many of these same tendencies. If you look at a case like Sella Law or Free Enterprise Fund or NFIB versus Sebelius, it doesn't seem to me like any of those decisions are significantly more interested in the kinds of real world facts you're talking about than the court is in the typical individual rights case. And throughout much of structural constitutional law, there are two worlds, rational basis world and the world of categorically prohibited exercises of government power, just as there are in the law of individual rights. And all this makes me wonder whether there might not, in fact, be deeper underlying causes that cross the boundary between structure and rights that are at work in both contexts, which might make it less useful to think about rightism and more useful to think about something like formalism or lawism or simply a lack of pragmatism, judicial pragmatism. And the common factors that come to mind that seem to me to cut across both contexts and which might help to explain these tendencies are first, ideology, second, some kind of understanding about judicial competence and the inability of courts to seriously engage with real world facts on a case-by-case basis. Third, the fear of conflict with the political branches and retaliation of some kind that might come from a broader engagement with real world facts across a wider range of cases. And then finally, concerns about judicial capacity and the ability of courts to handle the kind of caseload that they might worry about generating if they hold themselves open as willing to engage in this kind of careful analysis of real world facts in every manner of constitutional cases.
So the question is, do I agree? Or what is my response to that? So I'll say a couple of things about structure, and I'm thinking in real time here, right? So I don't have a prefab answer to the very good question. So first thing I'll say is that I think, broadly speaking, that that adjudicators and constitutional interpreters approach different kinds of questions in different ways, and different kinds of constitutional provisions structured in different ways often serve different kinds of purposes, right? So what you've referred to as formalism might very well, from a normative perspective, have a greater role to play in a wide range of structure-related disputes as opposed to rights disputes. And the reason I say that is because structural disputes are often disputes about settlement of the law. So one of the downsides of thinking about rights in the way I'm encouraging is that it leaves the law quite unsettled. So that's a significant cost. I think there's good reason. In fact, that's a feature, not a bug, when it comes to rights, because we're a pluralistic society and have to live together. And if you settle one set of people's rights in favor over another, then you're jettisoning part of the population from the constitutional project. I don't think that's the case with structural issues for the most part, right? Uncertainty is bad when it comes to, well, I'm oversimplifying, but there are a number of structural questions where the value of certainty and settlement is higher, in my view, than when it comes to rights disputes. That said, second thing I'll say is, I think a lot of this is an historical claim that I haven't studied, but that seems right to me, is that a lot of what we're saying is formalism around structure. And when we say formalism, I'm not talking about really specific controversies over very specific provisions, right? But certain kinds of originalist approaches, or approaches that try to make very specific historical claims about relatively non-specific provisions. They result from a growth within the scholarship production industry of people who are interested in those kinds of approaches. And that happens because of a response to what is viewed as a set of failures by courts in rights cases, right? So the originalism movement is, I think, largely responsible for for innovations in statutory interpretation and innovations in methodology and structural constitutional law as well. But that's because of, you've got a lot of originalists out there. And so they're applying their craft to lots of different kinds of provisions without being moved by the same kinds of anthropological considerations that I'm kind of focused on. The list of sort of fears that judges have, right? So it's too ideological. They want to not look ideological. They're worried about judicial competence. They're worried about conflict or retaliation from political actors. And so they want to try to stay in their lane. Worried about capacity or caseload. Totally agree that that's part of what's motivating them. And we should have conversations about whether those are legitimate concerns and how legitimate they are and how weighty they are, right? So I'm not a utopian, right? And I do think that there are costs and benefits to any approach to thinking about conflict. And so to the degree that you're going to really sacrifice judicial legitimacy in some serious way, if you were to do something closer to proportionality as opposed to categoricalism, that's a legitimate concern. I'm skeptical of that since, the rest of the world does this. But let's have that conversation, right? If you're worried about judicial capacity and about the number of cases that are going to be brought, that's a legitimate concern. Let's talk about it. Let's see if that's true. But if the alternative to that, if you believe you're actually not competent to handle disputes that overlap in significant ways with politics, then you shouldn't be a constitutional judge, right? That's just not, that's unavoidable. And so what I'm urging is that, in part because these are political conflicts, they should be generally resolved through political processes. Judges still have a role to play in setting the bounds for those processes, but that's what the judge's job should be, is setting the bounds and not deciding those questions themselves, because they don't lend themselves to pat judicial answers.
Thank you. Our next question is from Stephanie.
Hey, Jamal, can you hear me okay?
So that was a little bit low for me.
Having to call in on my phone because I had an issue with my computer. So I hope you all can hear me okay. Someone should send me a chat if you can. First of all, that was a fantastic address. Thank you. And as you know, I'm a fan of this project that you're doing. I think it's really interesting. I just had a couple questions and some reactions for you. One is, I agree with one of the key arguments I take you to be making about the fact that we should spend maybe less of our time and energy focusing about just the scope or the definition of what is the right, and more time thinking about, was the government justified in infringing on the right? And so one question I have for you is, I often come at this thinking about religious rights, since that's where my focus is. And so I'm curious if you prefer, for example, like a RFRA framework for adjudicating rights compared to the current constitutional framework, because RFRA spends less time debating whether or not a religious right has been triggered. We don't focus as much on, is the law neutral and generally applicable? Was there discrimination? It's just, was someone's right to religious beliefs that they substantially burden, and then we move on. And most of the focus, at least in my experience in these RFRA disputes, is more on the sorts of cost benefit analysis under strict scrutiny that I think that you're talking about. And so maybe I'm misreading your argument if that's not what you're thinking, but I'm curious to your thoughts about that. The other question I have for you is, I think it's a fair criticism that in the US we spend too much time sometimes focusing about the scope of rights, but the criticism that I've often heard of the proportionality framework is that judges have turned everything into a right. You have a right to go for a walk in the park, or a right to a dog, or there's lists that people tongue-in-cheek put together to highlight that once everything is a right, nothing is. And so I'm curious where you fall in terms of, do you view that as a extreme that is dangerous in the other direction, in terms of then turning judges into essentially super legislators? Do you have thoughts on how to put constraints in place that guard against that? Or maybe you think that that's not a problem. But thanks again for these really insightful remarks.
Great. Thanks, Stephanie. So on the first point, do I prefer, which I'll just take to be, do I prefer RFRA or prefer Smith from this perspective? And I guess I would say neither. Although, I like the pre-Smith framework, which I think is not precisely the same as the RFRA framework, even though it purports to be. Which is to say that, and this is consistent with really having a lot of negative things to say about Washington versus Davis. I also have lots of negative things to say about Smith, which I think is generated by, the fear of anarchy, right? As Justice Scalia says in Smith. And that's just not true. I mean, it's just not the case that anarchy results when you take seriously people's religious freedom claims. It is the case, right, that sometimes people who bring religious freedom claims are going to come into serious conflict with generally applicable laws, but you resolve those conflicts at retail, right? You see, look, is there a way of accommodating this without sacrificing serious objectives by the government that they're allowed to pursue? I think that believing in religious freedom requires that you take those claims seriously, and that if it's the case that you can accommodate someone, then you've got to, right? You don't just say they don't have a constitutional claim, or that doesn't seem very respectful at all. So the reason I say neither is because RFRA applies a strict scrutiny framework, and I don't think strict scrutiny is the appropriate framework either. And I don't think strict scrutiny is the appropriate framework because strict scrutiny assumes that certain rights are going to presumptively overcome whatever the government has to throw at them, unless the government's pursuing some very narrow set of objectives. And I think that that's not sufficiently respectful of democratic governance when it comes to unintentional interferences with religion. Now, if we're talking about intentional interferences, again, I'm not a fan of the tiers of scrutiny framework. I wouldn't apply strict scrutiny there either, right? But I would say that you have to justify that objective, and justifying an intentionally legitimate, intentionally discriminatory objective is hard. So I guess I would say I would favor something in between. And unlike a lot of people in my kind of camp, right? I'm my kind of ideological camp. Like I don't dislike Hobby Lobby, for example, which I think, at least certainly Justice Kennedy's concurring opinion, but I also think to some degree Justice Alito's majority, I think, are asking the right kinds of questions, where we can disagree about the outcome, agree or disagree about the outcome. But I think the right kinds of questions are, well, are there ways of accommodating this that don't, harm third parties and achieve the objectives of the statute? Or that's exactly the right kind of constitutional question I think we should be asking. On the proportionality, everything is a right. Rights inflation is what it's sometimes referred to. You have a right to feed pigeons in the park, and you have the right to ride horses in the forest, and you've got all these rights. We can have a discussion about whether that seems right from a philosophical perspective, but from the perspective of a judge who's trying to resolve a dispute under a constitution that is not super specific about you can imagine a constitutional system that says, we're going to tell you exactly what all your rights are. We're going to tell you, you got 400 of them, and here they are. And if you're not on this list, then you lose, right? And if you're on this list, then you win. But we don't have that constitution or anything like it, right? So under the kind of constitution we have, I don't really see any practical problem, right, with saying that you presumptively have a right to feed pigeons in the park, or to ride horses in the forest, or to eat your bagel on the sidewalk, right? Why not? Maybe that's really important to you. And so unless you've got more guidance about what, the things that we allow to be really important to people, and the things that we don't, and I don't think we have that guidance. I got no problem with that. I really want to know, well, if you don't let someone ride horses in the forest, this is a German case. If you don't let someone ride horses in the forest, well, why not? Why not? What's the problem with that? Right? Or, even think about mask stuff, right? Where the typical pro public health, right, response is you claim you have a right to not wear, to go without a mask. Like, what's the matter with you? Of course you don't have that right. We're in a pandemic, silly. But the question, the focus should be on, we're in a pandemic, and here's what the regulation looks like, and here are its specifics, and here's why it's just fine. Not, do you have a right? Because if you tell someone, and I now know this from observational experience, if you tell someone that they don't have a right to do something that they think they have a right to do, and that feels really important to them, they're going to get really mad. And they're going to think that the system is illegitimate. So I think judges should be trying to, within the bounds of what's possible, make people invest in and feel invested in the constitutional system, as opposed to sort of deciding, okay, there's some set of rights that you either don't have or have because of this vague text that I'm going to read in a very specific way because of my own methodological priors. And I think that that's destructive.
Thank you. Our next question is from Miles Lynch.
Again, thank you for, that was a great talk. That made a lot of great points. I just had one question, and I agree with you about the role of the Bill of Rights, but as far as what is the civic tradition in America and how we conceptualize rights, I feel like most people think first to the Declaration of Independence, which kind of sets our entire tradition in this concept of unalienable rights. And I wonder if kind of the shift that you are trying to promulgate might require more of a civic tradition shift in trying to figure out what's unalienable, what isn't, rather than saying what's a right and what isn't. I wonder if you have any thoughts on where the Declaration and where, I guess, general civics come into play in forming our constitutional framework.
So good. So I think that I agree that we do often associate rights with the Declaration of Independence, in part because of these words, right? But I'm reading I just threw up the Declaration of Independence to make sure I don't get the words wrong, right? We hold these truths to be self-evident, that all men are created equal, that they're endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, period. Next sentence, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, right? That's what the Declaration of Independence is about. It's about self-government. And that's how you protect those unalienable rights. It's not about judges, it's not about federal courts, right? It's about forming governments and having self-governing communities. And that's fully continuous with the subsequent Constitution and subsequent Bill of Rights. And all of, and not all, but a big chunk of the American civic tradition of the antebellum period, right? So I think you're right, right? As a matter of how what Americans actually associate this tradition with. But I think it's wrong to say that what I'll call the liberal tradition or quasi-libertarian tradition, it can just dates back to this unalienable language. That's not what they didn't mean. You get to wear your mask absolutely, or not wear your mask absolutely, right? They meant that you get to govern yourself. And I think we've gone away from that quite a bit, in that we think that we are to be governed when it comes to rights, that there's some separate category from politics, and we are to be governed by judges when we talk about that. Now, that I try to be realistic, right? So that insofar as this is an entrenched view, there's a lot to overcome, right? So if everyone thinks that this is a 200 plus year old view and that this is what we are as Americans, that's a lot to overcome, and you got to meet people somewhat where they are. I think that's right. But step one is to say, well, let's read the second sentence, right? And think more carefully about what it means to hold a right, and not just that the word right is there.
Evan Burnett.
You're on mute, Evan.
Hey, Jamal, I really enjoyed the talk, and I'm sympathetic with what I take to be your overall project of leaving us more space for politics outside of the courts and tamping down the political volume for the sake of greater civic peace and deliberation. But I am very skeptical of your prescription for what ails us, because I don't think that telling somebody who imposes a mask mandate that they're wrong on the facts. And in fact, if you look at the nuances of this regulation, it's reasonable, is any more likely to satisfy them than telling them that, well, you don't have the right to not wear a mask if you choose it in the first place. And the basis for this is not just my intuitive speculation, but work on cultural cognition that Dan Kahan in particular has developed in recent years, that focuses on the degree to which even our perception of what we might like to think are just technocratic facts out there in the world are not just given to us. They're mediated by theories we have about the world, including moral theories. And as much as we like to engage people in terms that seem to be neutral and given, they're quite often not that way. And if what you're suggesting is that a court that focuses more on factual controversies than determinations of who has a right and who doesn't, or whether a right exists or is not, is going to be less controversial, I do think that's, I'm not entirely persuaded by it. And to the extent that the concern really is to give us more space for politics, something like jurisdiction stripping over certain issues might be a blunter, but more effective approach to dealing with some of the problems that you're concerned with, because that way you don't have to decide one way or another whether there's a right or not, or whether the facts are one way or the other. It's just not up there for deliberation by the courts, and we deal through it through legislative or other means.
So thanks, Evan. So first thing I'll say is I have some sympathy for various forms of jurisdiction stripping, and long have. That shouldn't surprise you that much. But What I'll say is a couple of things. So one is you're skeptical that the prescription will lead to greater happiness, among defeated litigants. I'm not going to try to contest that. I'm making not really an empirical prediction, right? So much as I don't know what I should call it. It's to say it's just to say that if someone who has been told that you have in fact no right to decide whether to wear a mask or not, says, I think that that's totally wrong. I think I do have a right. I have some sympathy for that person, right? If that person is told you have a right, but there's a law passed, the law seems fine, and that person says, well, I still disagree, and so therefore I'm going to storm the castle. I have no sympathy for that person, right? That person has decided not to live in a political system anymore. So I'm making not just a sort of empirical prediction, I'm making a normative claim about how judges should do their jobs. I think, in Cultural Cognition Project, I'm very sympathetic to a lot of that research, but I also think that, we still should care about the margins, right? I don't think the claim of the project is it is impossible to persuade anyone of anything using facts. I reject that, and I think Dan Kahan probably rejects that too. I think he's saying that it's really hard to do that, and that you should be skeptical of how far you can get with facts, and that's a different claim and one that's consistent with what I'm suggesting, insofar as I don't think this is a panacea. I don't think there's anything you can do with judges that is a panacea to a deeply polarized, angry political system, right? But I do think judges should try to make things better rather than make things worse. And I both think that it's, my approach is normatively better. I would hazard an empirical prediction, but I wouldn't have that much confidence in it. And on jurisdiction tripping, yeah, again, I do think there's a role for judges to play, even in conflicts where I think it'd be better for their jurisdiction to be stripped. So, this is not to say it's all politics or should be all politics. It's to say that judges should be setting those boundaries in various ways, and I think there are lots of strategies for doing that.
Thank you.
Thanks, Jamal. We have several additional questions in the queue, but we are running right up against our end time here. Jamal, do you have just a few minutes to hang out, or do you need to go right at 6:15 your time?
No, I can hang out for longer, knowing that I'll lose some audience as well. Mm-hmm.
Okay, terrific. Well, let me just thank all of you for coming. I really enjoyed talking with many of you over the course of the day. The panels were terrific. I'd especially like to thank our distinguished commentators, panelists, and Jamal Green for this wonderful keynote, and also Bernadette Wilkinson and Brian Wilson, our wonderful program coordinators who made so much of this possible. If you need to leave now, of course, feel free. But I'm grateful that Jamal is willing to hang out here for just a few more minutes. And our next question is from Lawrence Klaus, if Lawrence is still here.
Thank you, Andrew. Yes, so this is just a specific follow-up to Andrew's question, actually. Doesn't power enumeration raise the same issue that you're articulating with respect to rights enumeration? The question of, do we focus on the enumerated subject, do this conceptual analysis, or do we focus on the reasons for distributing and limiting power? Would you apply the same analysis to power enumeration that you do to rights enumeration, try to get away from fixating on conceptual analysis, given that the certainty of settlement applies in each case if we're going to get to what government's actually able to do?
So I guess what I'd say is I'm not as committed to it in the case of power enumeration, because there are some very specific costs that I think are associated with how people in a diverse community understand what their rights are, and that if we didn't have those, if we weren't worried about that, right? If rights were not identitarian in the way that they are, then I would be less worried about the stakes of the approach that I'm suggesting. So I think structure, I won't say it can never be identitarian, right? And there have been times in our history and in Australia's, Laurie, in which structural issues have been identitarian. In fact, they almost have to be in Australia, right? But certainly not to the same degree. And so I'm just less animated in the structural context. I'm open to the argument that there are also good reasons to be worried about a certain kind of categoricalism or formalism in the enumerated power space. I'm very open to that, right? But it just doesn't happen to be my focus because I think the stakes are different.
I have Chris Schmidt next in the queue.
Hi, Jamal. Thanks so much for this talk. This looks great. I can't wait to read the book. So I'm very persuaded by your critique of Rightism. It just struck me that the way you framed, at least in the presentation here, was very court-centric, very judge-centric, right? And certainly we can say that this is a locus of the problem, but it also strikes me that if you look into broader society, particularly over last 100 years of American history, there's a lot of other actors who have participated in this. I'm thinking particularly of social movements, right? If you look at the way social movements frame their claims, they oftentimes do fall back under rights, and often a very hyperbolic definition of rights in a sort of unconditional sense. But there's utility to that, right? When you're mobilizing people, you're trying to get people on your side. So it does strike me that this both contributes to the court story, but also has an independent strand that could also be something that needs to be addressed if you're trying to diagnose the scope of the problem.
Good. So this is, I think, maybe my biggest source of anxiety about the argument, right? Is that it is very court-centered, and I don't either in any of my writings or in the book. I'll just tell you that in advance. I don't have a complex story of the relationship between how courts are talking about these things and how people outside of courts are talking about these things. I just sort of assume certain things. That I think is fair up to a point, but only up to a point. So I think you're right to press on this. A couple of responses. One is that I actually think, so I'm not against rights claiming, right? I'm in favor of rights claiming, and I'm in favor of rights inflation, in fact, right? So that the argument is not we shouldn't recognize people's claims in terms of rights, but that we should enable them to articulate their claims in terms of rights without being afraid that they're saying something crazy, right? So if I say I've got a right to food or a right to health, if you're wed to the American framework, that sounds like you're saying something crazy, right? And I want to enable and provide space within legitimate, ordinary constitutional law for that kind of claim making. So that, in that sense, it is consistent. And maybe I'll leave it at that for now. You're certainly right that rights claiming doesn't just happen in courts, and I would like, in part of this project, is to have courts speaking a language that is intelligible outside of courts when we're talking about rights, and that I think is consistent with the kind of democratization of rights mobilization that you're referring to.
Thanks.
We have one question remaining from Joshua Braver.
Hi, Jamal. I really enjoyed the paper. I buy the critique. Just for the sake of it, I wanted to push back a little bit or ask a couple questions. One, it's kind of similar to Christopher Schmidt. I mean, I'm all in favor of depolarization, but I'm wondering what kind of politics this will actually produce. And if European style proportionality is the framework, it seems to me that a very technocratic kind of proportionality method might produce a very technocratic type of politics, a type of politics that seems in tension with your goal of transparency, or Schmidt brought up, Chris brought up the idea of social movement mobilization. It just seems like, to me, these kinds of court decisions are less clear exactly about what the right is, because it's so situational in retail, so it's harder to mobilize around it, and always leaves the right lacking some kind of essential content that might be hard to mobilize around it. And that is part of my second question too, which is I wonder if it leaves the right less sturdy in moments of crisis or emergency. Of course, we know in the US courts have a very mixed record, but at the very least, if there's a right that has a clear content rather than always being defined at the retail, we can point to moments of hypocrisy. But if it's always situational and contextual, it seems like that's a real easier out than courts currently have in moments in which they're really trying to protect rights against overweening government, incursion.
Great. So two points, and I'll try to respond to each of them. So one is, well, maybe really 3 points, because there's an overarching question of what kinds of politics I envision. And I'll just say in very broad terms that I think it can be easy to come away from the kind of argument that I'm making as a suggestion that, that there'll be there's something conciliatory or like there's a kumbaya political moment that I'm envisioning, and I'm not envisioning that. I'm envisioning conflict, but in a political space, and that when people engage in conflict in a political space, that can lead to stasis, as it has so often in the U.S. But that the role of the judge is to force people to have those conversations. I don't like technocratic judging, and so you said European style proportionality. I'll just say global proportionality, and that's practiced in different ways in different places. I prefer Canadian cases to European cases in general, partly because it's only a few hours away, and so I think it's influenced by some of the American ethos. I'm not cheerleading for any particular form of proportionality. I think that asking questions and focusing constitutional review on back-end questions of what the government's doing and how it's affecting people is the right set of questions to ask. Beyond that, what it looks like, that can be autochthonous to various legal cultures. Formulating an American form of proportionality, I think that's particularly suited to America. That's fine. I don't object to that. On the second point about less sturdy in a crisis, I think of this as kind of shouldn't we adopt a pathological perspective on rights? And I just think not. I mean, the thing that has to be kept sturdy is not just people's individual rights protected by judges, right? It's also democracy. It's also laws that people pass, which are also often trying to protect people's rights. And so if the cost of making sure, and there's of course an empirical premise embedded here too, that it matters in a crisis, right? But assuming it does matter in a crisis, which is, as you've suggested, maybe a shaky assumption. If the cost is when that crisis comes, people's rights are going to be violated. If the cost of that is people's rights to formulate governments that pursue their rights through politics is just endlessly sacrificed when we're not having a crisis, that's not an acceptable cost to me. Right. It's so like, we're in a crisis right now, and it's a crisis that requires politics, not a bunch of individual rights. Right. So, crises take different forms and require different solutions. And so I think that when judges do their jobs, they should do it as, with the stakes of the conflict directly in mind, as opposed to the stakes of a hypothetical conflict that's not in front of them. And that's kind of my bottom line.
Please join me in thanking Jamal Green.
Thank you for your questions and your attention. I've enjoyed this.
Hope to see you all around the way sometime soon. Take care.